Welcome to the First Rate Law Podcast. I'm Bobby Rate with my co-host Tom James. We're here today to talk to you about yet another thing that'll help give you confidence that if you're involved in an accident, if you're injured due to the negligence of another, you think of us, you reach out to us because of what you learned during our 12 series podcast. Today, we're going to talk a little bit about some of our successes, and we're going to throw in there some of our challenges. It may have to do with the success, or it may have to do with a case that's totally separate. And I just wanted to start with one of my cases. It was actually my first trial verdict, and it had both the things. I was very happy that I got a verdict on this particular case because of the challenges. And that is this. I was representing a gentleman who, on his face, was apparently a very nice guy. When I met him, he was a nice guy. He got handed down to me from one of the senior partners at the last law firm that I was at. Quite frankly, and it went without being said, but it was known, he didn't want to deal with this case, and he knew he'd have to go to trial. I was anxious to get a trial verdict. I had been practicing for, I think at that point, 2 years, and I lost my first couple of cases. So I was taking anything. I wanted to get experience. I wanted to get into court, and I took this case. I met with the guy. There was just one huge problem, and that was this. He had previously been in prison. In prison, he had what's called a neuropsychological evaluation, which is an evaluation done by a neuropsychologist to determine if someone suffered a concussion, a head injury, a traumatic brain injury. And there's generally a report associated with it. And at that time, he was determined to have had a head injury. In this case, he was claiming he had a head injury. So we go forward, we prepare, we go to trial. I knew I had to try to keep out the fact that he was in jail. That would obviously hurt us if the jury knew he was in jail. And I was successful for the most part at doing that. But the fact that he had a previous neuropsychological evaluation did come in because, quite frankly, it had to come in because we had to compare and contrast. So the jury now knew that this was done in prison. So I couldn't keep that out. I did keep the reason that he was out. And it so happens that when I had the defendant, the young man who rear-ended my client on the stand, I was able to get him to admit that he saw my client in the vehicle, knocked unconscious, passed out. That kind of saved the day on that case. And although I was very, very skeptical that I would be getting a verdict because of the overall situation and because I was, quite frankly, a little scared of the fact that this guy was in prison, the truth of the matter is a combination of getting the defendant to say that he saw my client unconscious and noting very loudly in my rebuttal, which is the part of the case, the very end, when you as a plaintiff bringing the lawsuit get a chance to go and do your rebuttal after the other side, the defendant, their representative does their closing. I was able to jump up in my rebuttal because the attorney went a little too far in talking about imprisoned, head injury before, all this stuff. And he just threw in there drug addict when there was absolutely no evidence whatsoever of this young man being a drug addict. I jumped up. I talked about the fact that you can't trust the thing this guy says. Look at this. He's trying to pull one over on you. I got a $100,000 verdict. And there was no prouder day than going back to the law firm and telling that senior partner, hey, that case that you didn't want to try, we just got a $100,000 verdict. And for a young attorney who hadn't gotten a verdict, that $100,000 for this man was everything. It was a great experience, and I overcame a big challenge, obviously. Tom, why don't you tell us a little bit about a couple of your big verdicts or settlements or some success stories?
Yeah, obviously, right? We both have a lot of these. With your 35 years of experience, my 21 years of experience trying cases, representing people who've been seriously injured. So I'm going to start off by talking about two trial verdicts that I had, right? And a trial verdict means we're going all the way. You have a jury, and then the jury makes a decision on what it takes to compensate someone. It's different than a settlement. And then I want to talk about two settlements, and then I have a really good story at the end. But you got to stay to the very end to hear the good one. And it's not about $1 million, right? That's the best part about this story. It's about doing the right thing. and taking that case to really stick it to the person who deserved it in that one. But let's talk about the two big jury verdicts that I have. So back in 2002, I had the honor of going to trial for this great family, local family, out in the Howell area. Um, and this family was a husband, a wife, and two children. And the children were little, right? They were littles, both under 3 years old at the time. And he was a garbage collector. And he was the sole provider for this family. He's out collecting trash, doing his job, when another car comes by and hits him in the head, knocks him unconscious. And for the next 9 years, we litigated that case. Yes, I said 9 years. That's unusual. There were multiple appeals going on. The defendant was arguing, oh, it wasn't us that caused his injury. We didn't hit him. There's no evidence. And in fact, in all the settlement negotiations that we had on this case, they wouldn't offer more than $25,000. Right? This was a man that was supporting, obviously, his entire family. He was making very good money as a trash collector, and he was never going to be able to work again. And so, I'm meeting with their family. We're getting ready for trial. I'm at their house on a regular basis. I'm getting to know all of them. I mean, my wife met his wife, right? I knew his kids. My kids met his kids. I mean, it became a very intimate relationship. And in fact, if you want to read more about it or hear more about it, if you go to our website, right, www.firstratelaw.com, RAITT, you'll see a story under my bio where CBS came out and interviewed me about this and interviewed the family about this verdict. Anyway, that was sidetrack. Side note. Anyway, we go to trial. The trial lasts a week and a half. And during this whole time, they're accusing him of faking. They're accusing him of not doing his best to get better. All of these things, very insulting and humiliating and demoralizing for him and his family to have to sit through. But luckily, the jury saw through it, right? They didn't listen to any of their bullshit. They didn't listen to any of that other stuff that went on because they knew the real person. My client got up there and he was honest. Unfortunately, he was breaking down crying a lot because he was going through the struggles, not only physically of what he was going through, but mentally of being the care provider for his family. Now, all of a sudden, being the person who had to be cared for in his family. All awful stuff. And thankfully, the jury saw through all their shit and awarded him $14.2 million in that case. And I was proud. I was proud to represent this family. And I'll never forget that experience. And in fact, we're always talking about texting. He and I text on a regular basis. He's just talking about how he was in a fantasy football league. I was talking about my fantasy football leagues. So we still keep in touch. And that was years ago because he's a friend of mine now. So that's one, right? That's the one that stands out most. There was another case early on in my career. I mean, we're going back like 18 years that resulted in a $5.6 million verdict for a very nice gentleman. I mean, I love this guy. I loved his wife. I mean, they were the homeowners association presidents. They took care of everybody. They were the leading donors to their church before his injury, but he sustained a very bad injury. And that insurance company refused to offer anything adequate in the ballpark of what it would take to compensate him for never being able to work again and all of these other things. And I'll tell you what I learned in that case. I learned, and again, this was early in my career, that the witnesses, right? The lay witness, we call them lay witnesses, but they're your friends, they're your families, they're your neighbors. These people have valuable insights on the losses that people are going through, right? And his neighbor, I believe, gave the most impactful story and testimony because his neighbor got up on the stand. Again, he doesn't have a dog in the fight, right? Whether this gentleman got $5.6 million or whether he got $5, he doesn't have a dog in that fight. So he got up there and he told an honest story about how my client was kind of the guy in the neighborhood. If something broke, they would call Tony. If something, someone needed to get towed out of the snow, they would call Tony. And then he told this story about how after the collision, he got a call from Tony's wife. And Tony's wife said, "Hey, I got stuck in that area in our subdivision. Can you pull me out?" And he remembered that Tony had been badly injured. He goes and he helps Lisa out, and he pulls her out. And then he remembers driving by their house, and he remembers Tony standing in the window, just staring and watching. And he said that was one of the saddest moments of his life, because the one guy that was taking care of everybody now had to be taken care of. And it really struck home, right? It struck me because, again, early on in my career, you get caught up on these things like, what are the injuries, what are these, what surgeries did he have to go through? But that's not what makes a case. It's not what makes a difference to a jury of your peers. What makes a difference to all of these are what you lost, the harms that you've suffered. And we do it better than everybody else because we get to know you. You become part of us, and we become part of your family. And that's the difference that we provide. And that's where these stories really kind of hit home. I mean, I love these guys, right?
No, you can see it when you talk about the cases, and I know I do the same thing. And Tom is right. The way you do best with your clients is getting to know your clients, because you're their voice, you're their representative. You can tell their stories, but you can't tell their stories if you don't know them, right? And I had two clients, very similar situations, very similar clients in many ways, and both unbelievable results in jury verdicts. The first one was my first seven figure, so over $1 million verdict. It was like a $1.5 million verdict. It was against Rite Aid drugstore. I don't even know if Rite Aid exists anymore. It was about 25, 26 years ago. I'd been practicing about 7, 8 years. My boss came to me with a picture, and it was a picture of a little feeble, what appeared to be older woman in a hospital bed. And he said, "Do you mind going to this young lady?" And he winks at me, young lady's apartment. She claims to have gotten injured at a Rite Aid. So, low man on the totem pole, whatever it was, I go out there thinking very negatively, and I meet her, and I love her. I love this woman. Her name is Rosemary Kankel. She's passed away years ago. And I met with her for like 3 hours. And what I learned in a general sense was this young lady of 62, she looked like she was 72, 62, had been walking with crutches since she was 11 years old with terrible rheumatoid arthritis. Her hands were curled, her feet were curled. She had always used a scooter. She had been able to drive, she'd been able to take care of herself. What happened to her was very simple. She was walking through those sliding glass doors at a Rite Aid. They closed on her and she dropped. Long story short, there was no video surveillance. There was nothing to prove that this happened. It was her word. And the problem was she was complaining of terrible disabling pain in her buttocks area. And her rheumatoid arthritis was so bad that at the diagnosis stage in the emergency room, they simply put bruised, gluteus maximus, because they couldn't see through all of the bone, through all the decay that this woman had experienced now for, going on 50 some odd years. So that was her diagnosis, a bruise on her ass, right? I loved her. I was going full steam ahead. And the turning point came when we found out that we now just didn't have to bring what's called a premises liability case for getting injured on a premises. We had to bring a products case against the door manufacturer because she was claiming they closed on her, held her open, and she dropped with crutches on her butt. We had never handled one, and my boss said, "Let's refer it out." I begged and pleaded. I asked him to let me handle it. And I went to bat for this woman. And long story short, she was probably amongst my favorite clients for sure, but also one of my most intelligent clients. When we do discovery on these cases, when you go through a bunch of period of time getting information from each side, it's called discovery. One of the things you do, you probably heard of depositions. Well, written depositions or written questions are called interrogatories. We send these questions out to my client. We get back the answers in pencil with very faint lines under each of what she said. We read through them. We didn't add a word. We didn't type them up. we sent them off to the defense attorney. They were perfect in every way, and it was honest and it was real. Fast forward to the trial, because they weren't doing anything on this case. They didn't believe it happened. They thought we were lying. The attorney for Rite Aid was kind of going through the case, hoping that the attorney for the door company was going to carry the ball. Well, Rite Aid brought a motion to get thrown out. They said, we were told we're not to touch these doors. So what could we have done wrong? The judge did what's called took it under advisement. He didn't make a decision yet. He was going to wait and see how the trial went. So we go through the trial. My client testified. She testified very well. The only objection was the door manufacturer's attorney went up to the judge and said, Judge, this is an act. This is put on. Every single word she said to answer these questions was the same way she answered in the deposition. And I looked at the judge and I said, I guess that's what happens when you tell the truth. The judge laughed. He said, go sit down. We went and sat down. Then we played a video that we had where our expert went out to the scene. He put his briefcase in the door jamb and it closed on his briefcase. I went out to Florida during the discovery period and I took their expert, who was the door manufacturer design guy who designed these doors. I took his deposition and I asked him flat out, with this design, with your sensors, nothing will close on these doors? Nothing. I said, not a pebble, not a person, obviously. How about a briefcase? He said, no. He comes in, fly him in. He's on the stand and he's giving the same testimony. So I go to cross-examine him. And I said, are you telling this jury that if I put a briefcase right there, it's not going to close? No, these doors with this sensor are meant not to close on a thing. I played the video. The jury, the guy in the back, it was an older gentleman, stood up and said, hey, look, it closed on the briefcase. And my client leans over with a big smile. Now my client is in a wheelchair. She had to get a hospital bed. She had to sell her car. She was never the same. She was in a disabled condition. Now she's completely reliant on people and no longer independent. We ended up getting $1.5 million for that client. And to this day, I see the attorney that represented the door manufacturer and he shakes his head. He couldn't believe it. But you know what it was? Tom and I always talk about this. If you have a really good, honest client, and if you have what we call a villain or a bad guy on the other side, it's a great recipe for success. And that leads to my second one. Very similar in this sense. I got this referred to me from another attorney because it was another injury at a drugstore. Like all of a sudden, I'm the drugstore specialist. This one was even more interesting, I'll say, because the only facts I had is that one of those tri-fold chairs, I don't know if you're not old enough, you probably don't know what I'm talking about, but there were these chairs back in like the 70s that were tri-fold, and they stuck around for years after, but weren't used as much. Multicolor rubber wraps on them, and they opened up, and you would lie out in the sun on them. Apparently, these were on the top rack at a CVS drugstore. My client claims that she was looking at it, couldn't see the price, asked an assistant manager to come over, and that as my client is looking down at the lower rung, this assistant manager hit the chair over, hit her in the head. Lo and behold, in the ER, diagnosis, bump on the head. She told me, my client, when I met with her, that bump on the head caused XYZ, headaches, I'm having problems, concert, all these problems. But the problem with the case is she didn't want to go to the doctor. Fast forward to a time when we were trying to resolve it, closer to trial. I didn't think this case was going to be good in trial. I didn't think with the lack of treatment we were going to get a lot of traction. And we had a pretty decent offer from the defense attorney who knew me, who knew that if we did try it, I was going to give it my all and hopefully do well. He convinced his people to come up to a $300,000 offer. I called her. I said, good news, Mildred. I said, they're offering $300,000, double what it was evaluated at back when we did an evaluation with a panel. And she said, let me pray on it. And she called me back the next day and said, it's just not enough for what I've been through. And what I said was, I have to come see what you've been through. I got in the car. I drove to her house. I met her 92-year-old mother. I met her sister, who was a prosecuting attorney. My client did billing for DTE. She had done it for 18 years. What I learned in that 2 hours at her house is she had sticky notes all over the place, making sure she turned off the stove, making sure she turned off the lights. She was no longer allowed to drive her granddaughter, which she loved to do, to school because she continually missed the exit. And as she said, my granddaughter would say, Grandma, you missed it again. Now I knew what I had. And what I had was a case that I should have been in that house a lot sooner. And I wouldn't have even thought of having her take $300,000. What that case resulted in was a $4.6 million verdict. And I was so happy when I saw my client who kept her head down the whole time and explained to the jury and from the witness stand what it was like to sit there for 2 weeks, like big rubber bands around her head, pulling them and pulling them and pulling them as her head pounded. And tears came to her eyes. And me and three jurors, tears came to our eyes. Hear the jury say $4.6 million, which, by the way, was at that time the largest resolution I had ever had for a client that I absolutely loved. And there's nothing more satisfying than doing really well for a really good person. Any other stories, Tom?
Yeah. So what's interesting, right? And it reminds me, when you tried that case, we were working together at our prior firm. And I remember, because we used to roundtable these cases, right? I mean, you talk about them, and as you would bring it up, just the pure facts alone, right? The pure facts alone, I'm like, you're crazy, right? You're crazy for going to trial. You're crazy for not convincing your client, right? You got to convince your client to take that 300,000. But again, right, I hadn't met your client. I hadn't been
And
to her
again, it
house.
wasn't just the client on that case, like we talked about a little bit before. The
Yeah.
assistant manager got up on the stand and she said, "That's not the chair. I didn't knock
She
it
lied.
over. There was a little chair." They brought out this little baby chair. My client's like, "What the hell's that?" They brought out a little baby chair, and she said, "It never fell. It tipped and it hit your client's hand." So now we had a fabulous client and we had a villain, right? And what also is unbelievably ironic with Tom and I is that CBS didn't come out and just shoot him on his case. They shot me that same week on my case because they were out from California to Michigan. And so we both, on our website, www.firstratelaw.com, have those CBS shoots, and they were great. I brought my clients in. I hadn't seen them in years. It was great to reconnect. Her sister came in. It was very nice. And it's always great and very gratifying to do well by these good people.
Well, I mean, but that just goes to show you the difference in advocacy, right? So your average attorney is gonna like just lay on them and probably, not go out there and meet them, not go out and see her house, not see all these post-its that actually make a difference, and then advise that she should go down a certain path. But that's not what you did, and that's what made the difference. And as soon as you got that verdict, I'm like, whew, all right,
Right.
that was amazing.
You no
Right? That was
longer
amazing.
talked a bunch of BS about me.
Yeah, I was no longer mad at you. But no, so I talked about a couple of verdicts, right? So, but there's obviously settlements too, because if you listen to our prior podcast, we talk about our process of, we do the demands and then we litigate, we try and get your case settled. If that doesn't work, we go to jury trial. So I don't want everyone to think, oh, we're talking about jury trials, everything has to go to a jury trial. It doesn't. Again, majority, 99% of the cases settle. And so of the settlements, right, I'm very proud of a $9 million settlement that I got for a client. And what made that one really interesting too is that case was referred to me from another attorney up north. And that attorney had already told the defendant, hey, you know what, we would take $2 million. We would take $2 million. The defendant refused to pay it. Through their attorneys. And so then he hired me and got me involved, hired our last firm, got me involved. And so as soon as we got hired, I said, reject that too. Anything that you heard from the prior attorney, that's gone. Now you're dealing with us. And so that case ended up resolving at $9 million. And so that was one lesson that we gave to the other attorney who referred it and said, hey, look, in the future, here's how you can do things a little bit different that'll help your client a little bit more, right? So that you can help the next person next time. Or right? Just make sure you get us involved earlier. If you get us involved earlier, we can make a bigger difference earlier. That brings me to my second example. Right. So just recently, and I mean recently, this week, I just settled a case for $4.5 million. Very serious injuries, obviously. But this case was also referred to me by different attorneys up north, but they didn't refer it to me to settle the case. They referred it to me to try the case because, again, all of our prior verdicts. And so in the process of getting, of working up the case, of talking with and meeting with the clients, and these clients, like I was having dinner with them on a regular basis. So I think I've had dinner with them 3 times now over the course of, it was only a short time period, about a year. Meeting all their extended family members, meeting everybody, getting them involved, sitting down and talking to them, learning that they didn't want to go to trial, right? I was hired to be trial counsel, but now that I'm talking to the clients, learning who they are, learning what's important to them, what they want to do, they wanted closure. They didn't want a trial. And so we got to talking a little bit more, found out exactly what they wanted, and then we rescoped the direction of the case. And now we're getting it resolved at $4.5 million without a trial, which isn't what they wanted. So the importance of that, I would say, is that you can always start with one attorney, but it doesn't mean you have to finish with that attorney. And if you find that that attorney that you hired first, and it's not us, obviously, that they're not coming over and having dinner with you, right? They're not coming over and learning about your family. They're not coming over and learning about what you really want. Then you need to reach out, right? Either ask them to get us involved or just call us direct and we can do an evaluation. But I think that's the big difference that we provide, right? We get down and dirty with the clients, so to speak, and we figure out what your real goals are here. And we work to achieve those goals, not our goals. We want to achieve your goals. So that's really important.
Yeah, I mean, part of going to an attorney and having faith in an attorney is that they know when to make the right call. I think that's in part what Tom's talking about. And he mentions the fact that they didn't want to, this particular client didn't want to go to trial, as it turned out. Well, sometimes you're in a situation where you have to explain to a client that wants to go to trial why it's a really bad idea to go to trial. We were fortunate enough to represent a young man who got injured in Virginia. He lived in Michigan but worked in Virginia. We had to bring the case in Virginia. We filed suit in Virginia. We teamed up with a Virginia attorney because that's procedurally what you have to do. And in Virginia, unlike Michigan, they have what's called contributory negligence, meaning if you, as the injured party, is as much as 1% negligent for your own injury, you get donut holes, zero, right? So he had a really bad injury. But there were a couple things he did when this huge metal box fell on the back of his leg and really just ripped his foot and shin apart that we were really concerned about. If the jury latched onto, they might say, hey, he was 10% at fault, not knowing, because we didn't know if we could tell the jury, it all depended on the judge, that gets him nothing. It was just such a risk. And we were able to properly counsel him. And we ended up settling that case for, I think, $750,000. And he wanted $2 million because that was the policy. And maybe on a good day in Michigan without that, legal challenge, we could have settled for something like that. But they knew and we knew that there was probably a 50-50 chance he'd get zero if he went to trial. But impressing that upon the client, explaining it to the client, having the client have faith that you know what the hell you're talking about is the thing that we do really well. And that's why, in that circumstance, he was able to trust the fact that we knew what we were talking about, because after all, the more our clients get, the more we get. So we're advising them based on our mutual interest. And a couple other challenges that I've faced, and attorneys at the firm face on a regular basis, come up in my largest settlement, which was a $6.95 million settlement for a 78-year-old woman who was hit in a vehicle, ended up going under the knife a day after the accident. She had some fractures in her cervical spine or her neck, and she never came out of the surgery. And 9 days later, they had to pull the plug and she passed. Now, a 78-year-old, she was an African American woman. The mortality tables, which we look at, which say on average, given the person's sex and ethnicity, how long they're going to live, she was past that point. I think it was like 74 on average years old for a female in Metro Detroit, say, and she's African American, lives to 75. So it's not like we could say she had X amount of years to live. And we went to work because we loved this woman and we loved her family. We learned from the family just what a great woman she was. We saw through her whole history as a teacher, initially in the Bahamas, through talking to her students, which we were able to do, through putting a video together, which basically was like a day in the life of someone given through her kids, her grandkids, and great grandkids, a 20-minute snippet of that, and then taking it to what we call a mock jury. We assembled like mock jurors to hear a watered down case, so to speak, the bare bone facts. We got some information from them. We did a couple different goes at trying to resolve it with the defense attorney with the help of someone called a mediator or facilitator. And in the end, this 78-year-old woman, for her family, through what she went through and then passing away, we were able to get what everyone thought was undoable, and that was close to $7 million. And it's because we really went to work. We took the challenges seriously. We took the deposition of the surgeon to get what's called conscious pain and suffering, meaning that she was actually experiencing and feeling things. He said throughout that entire 9 days she was on the ventilator. Because there's value, you get compensation for that. So these are hurdles that we deal with, that we have experience with, and we're able to get the best outcome given that. And one last story about an outcome. We were also fortunate enough to get a client who was involved in a truck accident in Ohio. She was from St. Louis, and she was a passenger in the vehicle. Her fiance was driving. Long and short of it, she signed a waiver to be on the truck saying, if anything happens, I won't pursue a claim or sue, etc. What happened was he fell asleep. They rear-ended a semi rear-ended them. The driver, her fiance, died. Her dog in her lap died. She suffered fractures in all four extremities and was in a wheelchair for almost a year, never to be the same, right? So damages wise, we have a pretty good case here. Two problems: the waiver, and there were three other claimants that were injured in this accident, all looking to get the $1 million policy involved. So we did a lot of work to get around the waiver, to get it in a position where the other side thought, if we go to trial, we could get well above our insurance policy. And we were able to settle. I think she got about 780,000 out of that million. The other claimants had to split the difference because we did a really good job getting down and dirty and showing the other side not just were her injuries that bad, but this waiver was not going to stand. And the truth of the matter was, she was by far and away a more deserving person than these others, given her plight. And so you're always going to face challenges, some more significant than others, and we've had a lot of experience doing both.
Yeah, I remember. I remember that case. That was before I joined. I joined with you, and I remember all the work that you had put in, and that got some pretty good recognition for all the work that you guys did. So great job on that one.
All right, tell us about your $2,000 baby.
Yeah. So this is the best story of all. I'm serious. And hopefully you guys stuck around, right? Because I know that this one's a little bit longer. I get it. But this one was the win of all wins, and it happened in my first year of practice. So my first year of practice, actually, the same senior attorney that gave Bobby the case to go try for his first time also gave me this issue to deal with.
We should have called him. We should have called him the dumper.
Right. Well, that could mean a lot of different things, right? So
we know what we mean.
But we know what we mean, right? So anyway, he has this client, very nice guy, obviously, and he was badly injured in a car crash. But all of a sudden, he gets this notice that he's being sued. and he's being sued for $2,500. And it's by this, this company that buys debt. So if you ever heard of these companies, they go around, they buy all this debt from like credit cards and, Art Van or wherever they do these loans. And then they buy like thousands of dollars worth of debt, and then they sue everybody to try and collect these things. They hope for default judgments. They hope for automatic wins when someone doesn't answer, and then they start a collection, on them. So it's really nefarious stuff. So anyway, he gets this $2,000 lawsuit, and he's like, "Hey, look, I might actually owe it." One of his injuries was a brain injury, and he's like, "But I just need to know what it was about, right? Wait, did I buy? I don't think I bought a couch. I don't think I bought a TV, but it could be something I owe." And so I said, "All right, I'll take care of it." I called the attorney, because every one of these lawsuits, it lists the attorney, and I'm like, "Hey, look, my guy just needs to know what this case is about. You say he owes $2,500. All you attached was this Excel spreadsheet that had his name and $2,500 on it. Can you tell us what it was for? Was it a couch, a TV? I don't know, just credit card debt?" And they had the gall to tell me, "We don't have to tell you what it's about." All right. Well, that's wrong. So I'm like, "Let's go." Right? You want to go? Let's go. Yeah. I mean, I used to get in a lot of fights as a kid, so let's do it. So I file an answer, and then I file a formal request. Tell us what this is about. They never answer that. Well, under the law, they have a certain amount of time, right? They have 28 days to give me an answer. They didn't. So I file a motion with the court. And I'm like, "Hey, look, they need to at least tell me what this is about." The judge said, "Yeah, you need to tell them what this is about. You can't just point to a piece of paper." And so they didn't. They didn't do that. So some time goes by, a few weeks go by. They're still not answering. They're still not providing anything. So then I filed this other paperwork that's called, we call it summary disposition, but basically, "Judge, we should win because they're not telling us what the case is about and not giving us the information." We scheduled a hearing date. I show up at the hearing date, and the attorney finally, right? Didn't return any of my calls or emails, but she shows up and she's like, "Hey, we're willing to dismiss." And I'm like, "Dismiss? F you. We're well past dismissing." And so I'm like, "We're going to a hearing, and I'm asking for money back." Right? You can't screw people over like this. And so we get to the hearing, and I outline everything to the judge. She says, "Judge, we were willing to dismiss this case, but I don't know why we're still here." And I'm like, "We're still here because you're wasting everybody's freaking time, and you're doing all these predatory, like, creditor actions on these people. You shouldn't be allowed to do it." Thankfully, the judge agreed. Now, instead of just dismissing the case and my client doesn't owe $2,500, the judge turned around and said, "You know what? For this type of conduct, you're going to have to pay that guy $3,600." So I know we're not talking about $1 million, right? No one's retiring on $3,600, but I can tell you that gave me the biggest satisfaction. Right? To get back at these predators that are going after people and hoping for these automatic wins just to like strip people of their money. And it's absolutely criminal. And I'm glad they paid for it. And in fact, they didn't pay for weeks. And I had to file another motion in front of the judge, and we got more money because they weren't paying on time. So that is literally one of my favorite stories, right? Of course, we're going to talk about 14.2 million, $9 million settlements and stuff like that. But very few things make me happier than to retell the story about this $2,500 that turned in $3,600 for my client.
And I never heard that one before. That's a great story.
What? That's the best story in the world. I know. It was a good time. So anyway, that's what we're closing off this episode for. This one was a little longer. I get it. But I know, right? I know that people like to hear about, right? They like to hear the attorneys flex because you see it on the billboards, all these other things. So although we don't like to come up here and brag or flex about this stuff, it is important to know, right? Rate Law, First Rate Law, is a law firm that not only gets to know you, that protects you, that does everything for you and will fight for you, but we get great results for our clients too, because we know what we're doing and we've been doing this a long time. So come to firstrate.law.com, and that's first, F-I-R-S-T, rate, R-A-I-T-T, and then of course law, L-A-W.com, or give us a call at 866-RATE-LAW and let us help you. Thank you so much.